Most people think probate is about dying. It's not. Probate is about ownership. More specifically, it's about what happens when assets are still stuck in the name of someone who's passed on. And here's the part that scares people once they finally realize it. I regularly meet families who spend thousands of dollars on revocable living trusts believing they had avoided probate, only to discover after both parents die that they still have to go through probate anyway. Imagine losing both of your parents, sitting in a lawyer's office, emotionally exhausted, grieving, overwhelmed, trying to settle everything, and suddenly hearing that you now need to open a probate estate even though your parents specifically paid to avoid probate in the first place. That's not a rare story. I see versions of it all the time. Families walk into my office angry, confused, and honestly feeling a little betrayed because nobody ever properly explained how probate avoidance actually works. They were told they had a trust. They thought that meant everything was handled. But nobody explained that a trust only controls the assets that are actually connected to it. I recently met with two adult children after the second of their parents had passed on. They sat down across from me looking absolutely drained. Their parents had done what responsible people are told to do. Years earlier, they hired an attorney, signed a revocable living trust document, believed they had protected the family from probate problems. They thought they had simplified everything. Instead, they were now hearing that probate was still necessary. One of them leaned forward and said something I hear all of the time. I thought the whole point of the trust was to avoid probate. If mom and dad had a trust, shouldn't everything have avoided probate? Honestly, I could not blame them for asking the question. In fact, it was exactly the right question. The problem is that many attorneys spend enormous amounts of time explaining the trust documents themselves, but very little time explaining how assets are actually titled. Families leave the office believing the trust itself is some magical, invisible force field that automatically protects everything they own. But that is not how this actually works. A trust only controls the assets that are properly connected to it. This is where I had to explain the difference between building a suitcase and actually packing it. I told them creating a revocable living trust is a little like hiring someone to build you a custom suitcase for an important trip. A good attorney may build an excellent suitcase. It may have compartments, labels, instructions, organization, protection. It may even be so expensive and beautifully designed. But at the end of the day, the suitcase only works for the things that you actually put into it.
Probate attorneys don't like this information getting out because it makes people wonder whether probate really is a big deal or not. If this sounds different from what you were told, please leave a comment. And if you want more straight answers, like and subscribe.
If you fail to pack something into the suitcase, then it still has to somehow get to the destination one way or another. Sometimes there is a backup method. Sometimes there is a frustrating workaround. And sometimes it becomes expensive because you essentially have to buy a new wardrobe at the destination after realizing you failed to pack what you actually needed. That is exactly how probate works. At its core, probate is really about retitling assets after someone has passed on. The legal system is trying to move ownership from the deceased person's name into someone else's name. If the asset was already positioned correctly to transfer automatically, probate may not be necessary. If it was not positioned correctly, then the probate process becomes the legal mechanism for forcing that transfer to happen. The problem is that most people, and frankly many attorneys, oversimplify this discussion into probate assets and non-probate assets. But in the real world, especially here in North Carolina, families usually experience three practical categories. The first category is the ideal situation. There are assets that were properly packed in the suitcase. There are assets titled directly in the name of the revocable living trust during life. If the trust owns the house, the checking account, the brokerage account, or other assets before death, then those assets generally do not need probate in order to continue being managed or distributed after death. The trust already owns them. The successor trustee simply steps in and follows the instructions inside the trust. This is the cleanest version of probate avoidance. There is no need to ask the probate court for permission to retitle the asset because the asset was already sitting inside the trust structure. This is what most families think they are buying when they create a trust, and when trust funding is done correctly, this part can work very smoothly. But then we moved into the second category. And this is where many families become frustrated because this is where legalese and plain English collide head on. I explained to them that there is another category I often describe as semi-probate assets. From the attorney's technical point of view, these assets avoided probate. From the family's point of view, they often feel like they still went through probate anyway. For example, a joint account with rights of survivorship technically transfers automatically to the surviving owner. Pay on death accounts technically transfers automatically to the beneficiary. Certain real estate survivorship arrangements technically avoid probate as well. Attorneys are technically correct when they say those assets avoided probate. But then the family discovers that the North Carolina probate court still wants paperwork proving all of this before the estate can be closed. The court may want copies of the survivorship documentation. The court may want account statements. The court may want beneficiary paperwork. The court may want valuations and supporting records showing why the assets were excluded from the probate estate. So from the family's perspective, they're still gathering paperwork, filing documents with the court, dealing with the clerk's office, and discussing the assets during the probate process. Honestly, I understand why clients find that frustrating. Think about how absurd that sounds for the average person when an attorney says, "Good news, the asset avoided probate," immediately followed by, "Now we need to submit all of this paperwork to probate court so the court can confirm it avoided probate." The distinction may make perfect sense from a technical legal standpoint, but from the client's practical point of view, it still feels connected to probate because the court is still involved. Then we discuss the third category, and this is where the real financial pain begins. These are assets titled solely in the deceased person's name with no surviving joint owner and no beneficiary designation. This is where assets fully enter the probate meat grinder. If a bank account is only in the deceased person's name, if real estate is individually owned without survivorship language, or if investment accounts have no beneficiary designation and are not owned by the trust, then the probate court usually becomes fully responsible for supervising the transfer process. This is the category involving the most delay, the most paperwork, the most frustration, and often the largest attorney fees because the legal system now has a major problem to solve. The asset is stuck in the name of someone who has died, and the court must now create a legally recognized process for moving ownership into someone else's name. That means filings, notices, waiting periods, accountings, requests for authority, and frequently a tremendous amount of administrative frustration for grieving families. By the end of our meeting, the family finally understood what had happened. Their parents had paid for a very expensive suitcase, but nobody had properly explained what's needed to be packed into it. That is why trust funding matters so much. The drafting of the trust itself is important, but the real rubber meets the road issue is how assets are titled and whether those titles actually coordinate with the trust plan. A beautifully drafted trust that never gets properly funded can leave families shocked to discover probate is still necessary after all. If you want to better understand how trust funding works, what assets truly avoid probate, and why so many families accidentally leave assets exposed to probate anyway, check out the free information available at freetrustcourse.com, especially the chapter on trust funding. This is where estate planning stops being theory and starts becoming practical reality. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.